Moreover, has the prosecution explained to you how a subordinate would know which are the orders that are supposed to be followed, which are the orders that are supposed to be ignored? Again, how is it that subordinates were able to figure out General Gotovine's intention to protect larger towns, but weren't able to figure out or implement his intention to stop crime everywhere else? We turn to paragraph 164 of the prosecution's brief. Although Gotovine, this is in the middle of the paragraph, although Gotovine issued orders that acknowledged these crimes and contained, at least on their face, measures to prevent their continued commission, the content, timing, and number of these orders reveal that Gotovine was pretending to address these crimes while allowing and encouraging their continuance. Pretending to whom, Your Honors? Pretending to his subordinates? This is General Gotovine is issuing internal classified orders. He's not issuing orders to the international press. Pretending to whom? I ask the prosecution. This argument is truly ridiculous, let alone the only reasonable explanation of the evidence. Moreover, once again, they failed to put this argument to any witness in the case. Not General Jones, not even to Mr. Tunis. The prosecution argues that by issuing multiple orders to stop crime, quote, it is only logical, close quote, that Gotovine was encouraging crime. Again, no footnote. You'll have to determine, Your Honors, whether the prosecution's logic is logic you're willing to adopt as the only reasonable interpretation of the evidence. At paragraph 718 of our, turning now to the attention of to the question of what the prosecution claims are measures General Gotovine could have taken. At paragraph 718 of our brief, we explain that the test is necessary measures are appropriate measures which show that the superior genuinely tried to prevent or punish, and reasonable measures are those reasonably falling within the material powers of the superior. Now, most of the steps that the prosecution identifies in its brief were never put anywhere. According to the prosecution yesterday, these were, quote, simple and obvious steps. Yet, the prosecution, for some reason, never put most of these simple and obvious steps to any witness in 2.5 years of trial. What you heard yesterday in respect to measures against the 134th Home Guard units was based on the military expertise of no one. They are the opinions of prosecution trial counsel, not put to any witness in the case. They are arguments made up out of whole cloth. Your Honors, when comparing the defense arguments and the prosecution arguments, we ask you to note that we called an expert witness who testified that he would have chosen General Gotovine's steps as necessary and reasonable measures. With respect to the measures suggested by the prosecution yesterday, no one testified that they would have taken those steps. Nevertheless, most of the steps that the prosecution suggested were in fact implemented. As mentioned previously, General Gotovine did not have to issue a separate order on reporting of implementation. General Gotovine did issue orders to enforce disciplinary measures, that's D204 and P918. The prosecution says that General Gotovine should have tasked the entities to control crime. This issue has been litigated extensively and doesn't require any further comment other than to say that we are confident that the trial chamber has well understood who was in command of deploying the military police for crime prevention, investigation, and prosecution. Moreover, I must point out that in discussing the military police, the prosecution repeatedly claims, such as in paragraph 238, that General Gotovine exercised, quote, command and control over the military police. There is absolutely no evidence for that claim in the evidence. Article 8 makes clear that command and control rested with Lautsch alone. It is evident that the prosecution still does not grasp the concepts of command and control, and that command is not synonymous with control. Mr. President, you tried to alert the parties to this distinction at transcript 2395, lines 8 to 19, and General Ferrand tried to explain it to the parties at transcript 4343, line 22 to 4344, line 4. Unfortunately, the prosecution still does not understand. The prosecution argues that General Gotovine should have imposed military curfews in Croatia. This argument plainly ignores Croatian law and essentially argues that General Gotovine should have enacted a military coup d'etat against the civilian government of Croatia. It is clear that General Gotovine did not have the legal power to declare a military curfew in liberated areas when the constitutional order of Croatia had been restored. Clearly, the prosecution would rather advance another hopelessly unsubstantiated argument rather than concede the obvious. Finally, the prosecution claims that General Gotovine should have removed or replaced commanders or imposed disciplinary measures against commanders. This was never mentioned before their final brief. Which commanders, Your Honors? For what? Well, we don't know. And the trial chamber doesn't know. Because the prosecution failed to put this theory to anyone. Not to Tunins, not to General Jones. The prosecution, of course, will now likely say he should have disciplined every commander or replaced every commander. Unfortunately, we cannot respond to any such allegation because it hasn't been raised before. Now, consider this. You are being asked to find that General Gotovine his failure to take such obvious measures was so clear, was so blatantly self-evident, that you should find not only that General Gotovine bears responsibility under 7.3, but that it went a step further to willful intent to allow burning and looting. Yet these obvious self-evident steps were never raised in 2.5 years of trial. I think that speaks for itself, Your Honors. We met the case the prosecution put forward at trial. The rest of these new arguments have no weight and no citation to the record. You must conclude that General Jones's opinion is a reasonable interpretation of the evidence. Finally, the prosecution completely ignores a fundamental issue in our brief, a fundamental issue we raised in opening statement, a fundamental issue we raised with countless witnesses in this case. It is ignored in their final brief and ignored yesterday. Why is it that no one went to General Gotovine after the 6th of August to ask him to do anything. How can it be that General Gotovine is in command of the military police, that Lausich is coordinating with the Ministry of the Interior on actions to be taken, and yet Lausich never once communicates with General Gotovine? How can it be that Moritz testified that General Gotovine's name never came up in conversations on this issue, or that the President's office never discussed General Gotovine on this issue, or that General Ferrand writes a letter, one letter, to General Gotovine after Operation Storm to complain about UNCRO vehicles, to complain about treatment of UNCRO at checkpoints, and to ask General Gotovine to help him write his analysis of Operation Storm for the Canadian government. Never wrote him a letter, or even included within that letter a claim that General Gotovine, your forces are engaged in widespread systematic burning and looting, and you must get them under control. It's completely unaddressed. Your Honors, there was a point at this trial where the trial chamber said to General Cross, you would expect that if you are going to be involved in implementation, you'd be involved in the plan. I submit to you that that is a blatantly obvious point that the defense accepts, but the prosecution does not. I take it a step further, Your Honors. It is a blatantly obvious point that if you are involved in the execution, you would expect that you would be contacted to address the matter. General Gotovine was not. In fact, we saw that General Chervenko, General Gotovine's superior, was prepared to directly address General Gotovine whenever he had a concern about General Gotovine. As we see in the alleged mistreatment of Alan Roberts, General Chervenko demanded an explanation from General Gotovine and got it. General Chervenko never once contacted General Gotovine to say, you are not complying with your obligations to enforce discipline. Your Honors, let me conclude by saying that it is absolutely abundantly clear that General Gotovine took all necessary and reasonable measures under the circumstances, and you must enter a judgment of acquittal. I will now turn over the floor to Mr. Keogh, who will address issues of the crime-based artillery and other matters.
Keogh, look at the clock. May I take it that you prefer to, will you take all the remaining 90 minutes, or will there be any further division of?
There will be further division. There is some concluding comments of approximately 30 minutes by my colleague, Mr. Ackerman.
Yes. Then I leave it to some extent to you where to take the break if it stays within the usual limits. Please keep that in mind.
Yes, Mr. President, I will, and I trust that the Chamber will want to break at the usual time of approximately 10:30.
Yes, but if, for example, if 10 minutes later you would be finished and someone else would take over, then we, of course, take the break 10 minutes later. That's, please proceed.
Certainly. Your Honors, court staff, my learned colleagues on both sides of the well, good morning. Before I go into the comments that I have on various aspects of this, I want to hearken back just initially to the comments made by my friends across the well on the need for accuracy and the need for the court to carefully examine citations in these briefs.